I'm Jackson Howder, and I've been asked to speak to you on behalf of the Department. The Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." This means we must be careful by the way we investigate and arrest people, because without the proper documents it's often illegal for us to enter homes or other buildings without a search warrant, to search for evidence or make an arrest. A warrant is issued only with probable cause, and an officer will swear by it. It will define the place to be searched and the people or objects that are to be seized. A warrant might not always be required, but it's often good practice to get one anyway, just to avoid any confusion and unnecessary responsibility to the officer. The Fifth Amendment reads, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service, time of war, or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property, without the due process of law, nor shall private property be taken for public use without just compensation." This means the suspects have the right to be indicted by a grand jury before being tried for any federal criminal offenses. It also prohibits double jeopardy or being tried or punished more than one time for a single offense. It gives defendant or suspects the right to remain silent, or in other words, not to speak if what they say could incriminate themselves. It says that people have the right to have their liberties protected by due process of law, and finally, any property taken by government for public use will be compensated for fairly. As stated in the Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury in the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This is saying that defendants are guaranteed a speedy trial. They cannot be expected to wait for their trial to begin, especially if it could be detrimental to their defense. They are guaranteed a jury of impartial people where the crime has been committed. They can speak to and with the witnesses and prosecutors who are charging them with the crime, and they can have witnesses called to defend them. They must be told what they are being charged for, and also a defense attorney can be given to them in case they cannot afford one to defend them in court. Finally, the Eighth Amendment reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted." This means that bail is legal, but must be adjusted to suit the crime, the accused, and the circumstances surrounding the situation. Fines that are overly high are prohibited, and cruel and unusual punishments are prohibited as well. This means that while defendants and criminals are being accused of a crime, they still must be treated fairly and humanely. Thank you for your time. This concludes my presentation, and I hope the best of luck to all of you.